Most notaries understand just the basics about their notary surety bond. In this video, I'm going to do a deep dive into the notary surety bond and why it's important. Now, some of you live in states that don't require that you purchase a notary surety bond. You need to watch this video as well because I'm going to talk about the advantages and disadvantages of not being bonded. My name is Michelle Riley. Most of you are familiar with me as an Alabama Commission Notary Public and Notary Instructor. But what you may not know is that I'm also a licensed insurance agent, have been for the past 7 or 8 years, and I'm licensed not only in the state of Alabama, but in 28 other states. This is a topic I know quite a bit about, and there's a lot for you to learn. So I hope you will stay tuned and engaged. Most of you already know what I'm going to show on slides 1 and 2. It's slides 3, 4, 5, 6, and on that may be new information. So what you probably already know is that the notary bond protects the signer and notary errors and omission insurance protects the notary. Again, in this video, we're going to only focus on that notary bond, the notary surety bond. I'm going to talk about errors and omission insurance in a separate video. And so again, the way that the notary bond is structured and set up, the focus is to protect the general public from any mistakes, whether they're accidental or deliberate mistakes made by the notary. We as notaries are personally responsible for the mistakes that we make when notarizing a person's signature. And not only are we personally responsible, we are financially responsible. Now, we're not the only role in the community that has this type of liability. You'll see that technicians who work on heating and air, the HVAC equipment, usually they are required to be bonded by the state. Plumbers need to be bonded by the state. Any occupation or role that has significant influence and responsibility to the general public, the state can make the decision to require, mandate that they purchase a surety bond so that when things go sideways, and things often do, the general public has um, recourse. All right. On the screen now, you will see a list of states that do not require their notaries to be bonded. So if you don't see your state on this list, your state requires when you're brand new and each time you renew that you purchase a notary surety bond. In Alabama, you know this, you should know this quite well, that purchasing that bond is one of the first things you will do in order to obtain your notary commission. Whether to be bonded or not lies with each state. The lawmakers, the governor, they all decide how do we want to manage the role of the notary in our state. Do we want them to be bonded or do we not? So again, that is a state decision. And yes, there are times when a state might decide in 2026 that based on legal cases that have come through the courts, that they may want to institute a new requirement that notaries be bonded, or they can remove the requirement. So it's very important that you stay up to date on your state laws regarding the requirements for being commissioned. You purchase a bond from a surety company. A surety company is a lot like an insurance company. The surety company will pay a fixed dollar amount to the signer who's been harmed and to any other third parties or victims. An example that I can give to you here, those of you who, let's say, notarize a will, you're going to meet with the signer, the person who wants to make sure their assets go to certain family members. So they would be the signer. But third parties could be if you make a mistake that on the notarization that affects the will being put into effect in time to benefit the beneficiaries. The beneficiaries could be the third parties, the individuals who were supposed to receive proceeds from the will and now are excluded from those proceeds because you did not notarize the will correctly. All right. So again, whether you're the signer, whether you're a third party, um, you can file a claim against the notary surety bond. The amount of money that the surety company pays out to the signers and third parties is capped at the amount of the bond. In Alabama, we are bonded for $50,000. The surety company will not ever pay out more than that. They can pay out less than that. The claim may only be $4,000. That's all the surety company will pay out. I'd like to give you an example of how a claim could be handled. When you notarize a person's signature and you make a mistake, and that mistake causes that document to be rejected, that could then cause the transaction to be halted. I gave you the example of a will. Another example might be someone is trying to pull out money from their 401k. Their former spouse or current spouse needed to get their signature notarized on the form. The signer is pulling out money to try to take care of some debt or financial obligation. You forget to stamp the form, or you do not complete the venue correctly, or you sign in the wrong place on the document. They mail in the form, it gets rejected, and now a deadline has passed. And now instead of owing a debtor or owing a debt of $50,000, interest is accrued, and now the signer owes $55,000. All right. And so in that case, they've got to start all over again. So in that situation, the signer has experienced a financial loss and the signer wants you to pay. It may be just paying the difference between 50 and 55, or the signer could claim, no, it's more than that. It's accruing every day. It caused me a lot of stress. We had to overnight documents. And so the signer would go to the party in your state that manages the notaries. In Alabama, it is our county's probate office, the judge of probate. The signer will know who to contact by either looking at our notary seal and seeing that. Um, Let me back up. They will go online to the Alabama Secretary of State's office and use notary lookup. That is where they will see which county issued our commission. Contact that probate office, and that probate office has an original copy of our surety bond. And so the judge of probate's office for each county will direct the signer on how to file a claim against our surety bond. The signer could also just ask the notary directory, hey, look, I'm not happy with this. I want $7,000 because that's what your mistake cost me. What's the name of your surety company? Again, other parties involved in that transaction can also file a claim against the bond. Once the claim has been filed, the surety company is going to review it. The surety company may reach out to the probate judge's office to clarify on and verify if the notarization was performed correctly or not. Why? The probate judge has a very good understanding about what notaries should be doing and should not be doing. The surety company should also reach out to you, the notary, to get your side of the story. And then a decision gets made as to whether or not the claim will be paid or not. The amount of each state's notary bond does get determined by the state. And so again, each state has a different amount, but most states, their bond amounts are $1,000, 5,000, 10,000, 15. Other than the state of Alabama, bond amounts range from $1,000 to $25,000. The state of Alabama is the only state that has notary bonds in the amount of $50,000. The term or the length of the notary bond will always match the notary commission dates. So if your commission starts on April 1st, your bond needs to start on April 1st, and then it runs 4 years if you're in a state where your commission lasts 4 years. But if you're in a state where it's 5, 6, 7 years, your commission, your notary bond will cover those same dates. All right? Issue date to expiration date, the bond and the commission need to be the same. Notaries who are bonded, you have 24-hour coverage. So it doesn't matter whether you are notarizing at work, at home, if you're a mobile notary or not, whenever you are using your seal, the bond covers you. Now notice I have a footnote or an asterisk. That 24-hour coverage statement, may not apply to those of you notaries who work for state, federal government offices and municipalities. You may be covered under a different type of surety bond that restricts your notarizations to and your bond to be limited for work purposes only. How are you going to know that? Well, for one, you, if you don't have a copy of your notary surety bond, that's a good indication that your situation is different. And that means before you even consider starting a notary business, um, notarizing away from work, you need to speak with your employer about the bond situation and find out what the limits are. This is very, very important. All right, next I want to get into the pros and the cons, the advantages and disadvantages of the notary surety bond. Let's start off with the advantages. Um, any professional that is bonded, it says to the community at large, the general public, that you are in a profession that requires you to be accurate, diligent, trustworthy, professional. So again, when you see that someone is bonded, it is to put the general public's um, fears at ease, reduce their concerns that you're going to do the job right the first time. And if there is an issue, if there is something that doesn't work out the first time, you are going to fix the problem to the customer's satisfaction. That's the expectation that your state has, and that is also the expectation that is set by the surety company, which is why they agreed to issue your bond. By being bonded, the claim process is streamlined so that the victims can easily and promptly collect the money, get the money that they are owed, instead of having to follow a lengthy, long legal process. So now I want to speak to those of you who are in states that don't require you to be bonded. Your victims, your signer and victims, obviously their first response to your mistake is going to be, hey, pay up, make this right. And if you aren't able to pay up or you refuse to, their recourse is going to be to file a lawsuit against you. All right? It takes longer, takes more time, but eventually a judge or jury will determine whether or not you are liable or not. For those of us who are in states where there is a notary surety bond, the surety company will handle that process outside of the legal system, speed it up, make every effort to make a fair decision. All right. Many claimants and victims will accept the bond payment instead of filing a lawsuit against the notary, thereby freeing up the court system to focus on other cases. So that's the other advantages of being a bonded notary. back to an imaginary victim, they may want back to the scenario I gave you, or the example of someone pulling money out of their 401k. All they really wanted was the $50,000 from their 401k. Here in Alabama, that's the max that the bond is. Even though the signer lost out, is losing out on 55,000, the signer, the victim, will say, you know what? I think I'm just going to get this 50,000 from the surety company, and because I need it right away. I don't want to go through all the lawsuit, getting them served, court dates, hiring a lawyer, and all that. I'll just take that and move on. And so, um, and in fact, statistics show that that is typically what happens. Most victims are not trying to get over on the notary. They just want to be made whole and move on. All right. So again, if the victim is only owed a few $100s, a few $1,000s, that notary bond really comes in handy for them. Now, that doesn't mean that they can't still sue the notary for any additional amount. They can, but most choose to just go ahead and get their money quickly. And again, that benefits the notary as well, or it could in some situations. And then finally, the price or the cost of a notary bond is very reasonable. If you look at the screen, you'll see the average cost of notaries across the nation. Most notaries pay somewhere between $25 to $75. And while it's not pennies, but in a way it is. So here in Alabama, this means all I have to do every 4 years is send $75 to the surety company, and they have set aside $50,000 in my name to pay out in case I make any errors. That is very inexpensive. Those are some of the advantages of having a notary surety bond. Now for the disadvantages. You see that first bullet, right? We notaries are required to repay the entire amount that was paid out back to the surety company. And so if my surety company pays out the entire $50,000, guess what? They are sending me an invoice, a bill, to pay the surety company $50,000. This is huge. I think nowadays more notaries understand this fact, but it bears repeating and remembering, which is why it's so important for notaries to keep mistakes and errors to a minimum. And when we do make those mistakes, to correct it quickly and fully. Now, traditionally, I kind of hinted at this. Throughout the US, most states set their bond limits to only $10,000, $15,000. A few have $5,000 bonds, in fact. Those amounts are very low. Remember, no one has 50,000 except for Alabama. There are a couple states, only one or two, that have bond amounts of $25,000. But most, it's less than that. And the problem is the victims deserve more than just 5,000 or 10,000. I say deserve, I should say notaries' mistakes cause victims financial harm that exceed $5,000, $10,000, $15,000. So that bond limit, especially nowadays, isn't high enough to cover all of the victims' financial loss, which means they're going to end up, they have the right to file a lawsuit against the notary anyway. Notary bonds only cover notarial duties. And so only mistakes that relate directly to the notarization of a signature are protected or covered by the bond. Checking a signer's identification, filling out the notarial certificate, administering oaths and affirmations, performing copy certifications. That's about it. Anything else that a notary is doing at a signing, at an appointment, won't be covered by the bond. All right, the notary is on their own. And so the surety company, that's what that claims process is about. What was supposed to happen? All right, it was a notarization. All right, did the notary perform the notarization according to their state laws, guidance, the handbook, the statutes? So those of you who are notary signing agents, when you're talking with the signer about the closing disclosure and you start talking about that interest rate and you give them wrong information, when you forget to have them sign the notice of right to cancel in the right place, and then it causes them and they want to pull out of the transaction, the refi, they want to cancel the loan, but they got the dates wrong because you wrote the dates. All of that is not covered by the notary bond. And so while you may think that bond is going to help you, it is not. It only covers notarial duties. Those of you who are apostille agents. Now, if the mistake you made is part of the notarization or copy certification, that's covered by the notary bond, as long as that is something that you're able to perform in your state. But as far as you getting documents to the Secretary of State or to the U.S. State Department, currying the documents and all, that is not covered by your notary bond. Once the bond pays out money to victims, the notary is no longer bonded and the notary's commission is no longer active. Yeah. In order to be commissioned in the states that require surety bonds, once that surety company issues a payment, you're no longer fully bonded. Best case scenario, you'll need to purchase a new bond. Worst case scenario, the surety company will be like, nah, we don't trust you anymore. You've demonstrated in this claim that you don't know what you're doing. You are not following your state rules, laws, requirements. You're not following notary best practice. You're not using reasonable care. When meeting with the public and notarizing their signature, you are no longer bondable. And they enter that information in a database. And while you can go try to be bonded with another company, when the agent issues the bonds, we enter your information in a database. The surety company decides whether or not to trust you again and approve your bond. In states where notaries are not bonded, the notary, give me 1 second. I'm not sure I'm going to be able, good, I can. In states where notaries are not bonded, the signer or victims must rely on the court system. And that's not always a bad thing. It is more time consuming. And I don't know too many people who want to go to court without consulting a lawyer. And so now we're getting into court costs, lawyer fees in order to come to a resolution, a more lengthy and costlier process. I'm going to pause there. That completes part one of this discussion of what you need to know as a notary about the notary bond. In part two, I'm going to get into frequently asked questions that I've been asked over the years and questions that I've seen posted in Facebook groups, on social media, and provide answers to those questions. So I hope you will watch part two of the Notary Surety Bond, what notaries need to know. Again, my name's Michelle Riley. I am a licensed insurance agent, and I do specialize in the Notary Surety Bond and Notary Errors and Omission Insurance. If you need to reach out to me, my contact information is on the screen. And if you reside in one of the states that is listed on the other side of the screen, I am able to give you insurance advice. And if you are in need of a notary bond or a notary errors and omission insurance policy or signing agent errors and omission insurance policy, I'll be happy to speak with you, talk to you about the amounts that are available for you to purchase, and complete that transaction for you. Even if we aren't in the same state, I am licensed in your state, and we can meet through Zoom or the telephone and handle everything through email and online. I appreciate you watching this video. If you want to learn more, please make sure you check out part two with the frequently asked questions and answers. Thank you so much for watching.